Welcome. I'm Jerry Oginski, a medical malpractice trial lawyer practicing law here in the state of New York. Today's topic is 10 reasons why you should not sue your doctor. Number 1, you like your doctor. And who doesn't? We all go to doctors for the benefit of getting better. We go to them for checkups. And when we're sick, we put our faith and our trust in them, hoping that they'll do the right thing and make us better. But what happens when they don't, or when they've caused injury as a result of improper medical care? So, should the fact that you like your doctor prevent you from bringing a lawsuit? Well, it might make you uncomfortable, but I guarantee you when you start to think about the disabling injuries you've suffered and how it's going to affect you for the rest of your life, you might think twice and might agree that it's appropriate, even though you like your doctor, to bring an action against him seeking appropriate compensation. Number 2, what good will the money do you? I hear this often from defense attorneys when they're trying to negotiate a case. They turn around and say, what good is the money going to do your client? They can't use it. They're disabled. They're in a nursing home. They're in a healthcare facility. It's not going to make a bit of difference. And you know what? The problem is that in our system of justice, we have no other way to compensate injured victims. And that is the only way to try and make a person whole again. We cannot turn the clock back in time to make the injury go away. It's impossible. So our system of justice allows us to seek compensation so that the money is used for the benefit of the injured party as well as their family members. So to answer the question, well, what good is it going to do? It's going to try and pay for the best medical care that the injured person can get, because why shouldn't they be receiving the best medical care? The other thing is that it's going to help their family try and cope with the injured person's disabilities. And for that, it's crucial to obtain adequate compensation. Number 3, the doctor's reputation will be tarnished. Well, I disagree with that. We live in a civilized society where people have an absolute right to bring a claim if they feel they've been injured by someone else. Most people in today's society recognize that simply because someone has been sued does not necessarily mean that they're a bad person or that they've done something wrong. It's for a jury to ultimately determine whether the claim that's being made has merit, and if so, whether the person should be compensated. And even then, it does not necessarily tarnish the reputation of a particular doctor. If the doctor has been sued 40, 50, 60, 70 times, then you would seriously question whether or not there's a significant problem with the doctor's work ethics and his morals, as well as his ability to practice medicine. But for the most part, that does not happen. Where a doctor has been sued a few times, especially in a high-risk specialty, whether it's neurosurgery, obstetrics and gynecology, surgery, most people understand that patients are unhappy with outcomes, they're disgruntled, and they bring lawsuits. But it's up to a jury ultimately to determine whether or not those cases have merit. Number 4, your doctor will not be banished from his community. And that's absolutely true. Just because a lawsuit is brought does not mean that there's any social stigma attached to it. Again, it may be uncomfortable for the doctor to disclose that he's the subject of a lawsuit. But until a determination and a final determination by an appeal court has been made that the doctor is responsible and is required to make payment, there should be no stigma attached to the fact that a lawsuit has been started. Number 5, your doctor will have to shut his medical practice if he's sued. Well, again, that's simply untrue and inaccurate. The doctor will continue going on practicing medicine, and hopefully the doctor will learn from whatever problems have arisen from your potential case. And many people don't realize, and they think that a doctor is going to lose their medical license to practice if they've been sued. That's simply not the case. Your case will proceed on through the litigation, through the course of time, and the doctor will continue on practicing medicine. The doctor will not be required to shut his practice, nor will the doctor lose his license. Number 7, your doctor may alter his records. That would be true for any case. However, it does not happen very often, even though most attorneys have seen it once or twice in their career. The reason why it does not occur often is because if a doctor is found to have intentionally altered your records, he or she will lose their license to practice medicine. No question about it. The State Department of Health is going to crack down and come down hard on any doctor who has intentionally altered a record. Number 8, your doctor may apologize and tell you it was all a mistake. And while that's very admirable and very honorable, it does not alleviate the fact that you have suffered injury at the hands of a physician who is charged with caring for you and treating you in accordance with the standards of medical care in the community. So again, even though you may like your doctor, and your doctor may come to you and apologize and discuss exactly what happened with you, that does not obviate the fact and turn back the clock to get rid of the injuries that you have suffered. Number 9, your friends and family may think you're a gold digger. There are some people in the state of New York who bring lawsuits solely because they are interested in the money. The majority of people who come to us who have been injured by doctors or hospitals really come to us seeking compensation for their injuries and, most importantly, seeking justice. Some people have the perception that they're only in it for the money, and they think that their families or friends who are bringing a lawsuit are gold diggers, just looking for the money. Majority of people are not like that, and although you may know 1 or 2 people who have that outlook, I tell you right now, in the 19 years I've been practicing law, that does not happen often. Number 10, your injuries are not that disabling. Well, as I've discussed in one of my other video newsletters, if your injuries are not that disabling, your attorney most likely will not accept your case, because we have to show not just wrongdoing, but that the wrongdoing caused injury and that the injury is significant and permanent. If your injuries are not that disabling, then most likely your case does not belong in court in litigation. Because if it's a temporary injury, if something that will go away, then most lawyers are not going to accept a small disabling injury, because the time and energy and effort that's needed to prosecute a case like this is significant. And that's it for today. I'm Jerry Oginski. Thank you for joining me. Have a great day.